Good evening. You reached another episode of Paid the Cost Podcast with Loyalty Above Betrayal with your boy Teflon. Today's subject is all about knowing your law. You know, all so often, you know, we can get into a word for word thing with officers or different officials, and actually think that we know what we know, and we just know what someone told us, and that don't mean it's right. Um, so I just ask you, you know, sit back. Get your ear full and just hear me now. You can believe me later. Paid the Cost Podcast, Loyalty Above Betrayal, Know Your Law. Okay, today our first subject is Constitutional Law Part 1. Looking at powers of the federal government. Judicial power, Article 3, Section 1. When you're talking about judicial power, it's always Article 3, Article 1 is Congress, Article 2 is the executive, Article 3 is the judiciary. Article 3, Section 1, the courts are independent of the president, Congress, political process. If subject matter jurisdiction, even subject, um, they have the authority to review an act of another branch, which found in Marbury. They have the authority to review um, decisions of a state's highest court. That's from Martin. Or a state statute, court decisions, executive orders. That's from Fletcher. They have the authority to review these four constitutionalities only, not whether that's correct or not, only for constitutionality. Judicial power limitation on limited power is found in the 11th Amendment. A state cannot be sued by a citizen of another state. That's the 11th Amendment. A state cannot be sued um, by a citizen of itself, of its own state. That's the 11th Amendment as interpreted by Hands. Now, the 11th Amendment only bars suits for damages. A suit is okay if the damages are sought against a state officer in the individual capacity. Like there are suits for damages, but they're okay. But in the context of that suit being against a state officer in the individual capacity, you can sue local governments, and the state and the federal government can sue a state. State can sue each other, but federal government can sue anybody who they want. Judicial power of the Supreme Court and their original jurisdiction. The Supreme Court have original jurisdiction, and that's the first court that hears certain cases. And these cases are cases involving ambassadors, ministers, councils, um, or you got to be aware that the state is a party. Looking at judicial power of the Supreme Court and the appellate jurisdiction. So, how do cases get appealed to the Supreme Court? There's two ways. They may hear, and there's cases that they must hear. Cases that they may hear come to the Supreme Court discretionary, a discretionary review. And cases going through the appellate court, the justices review these cases, and four justices of the court must vote to accept that case. And if they don't, it stays in the lower court. Lower court decision settles. There's also cases that they must hear. May hear a discretionary review, also called certiorari, I think. But these are cases that they must hear. These are direct appeals um, from a three-judge district court panel, and the Supreme Court must hear those cases. Judicial review of operation, looking at standing, you must have standing. To have standing, you must establish an injury of fact, which means it must be concrete and particularized. The harm need not to be physical or economic, but may be an effect to recreational activities. And it may be a future harm, but it must be actual or intimate. So you got to have an injury, and you got to have causation. So it got to be traceable to that defendant's conduct. and injury, effect, and that would remedy the harm suffered. Looking at judicial review and timeliness. This is the rightness, timelessness. This is where the plaintiff has suffered a real injury. Mootness is where legal proceedings have no effects. Looking at judicial review of judicial issues, kind of like advisory opinions, kind of like the court may not render advisory opinions. They may only render opinions of actual cases that are controversies. You can't just run around and say, "Oh, you should do this, you should do that." They can't. They don't do that. You got to have a case or controversy from the court. Declaratory judgments are okay, but addressing political questions are, as far as like where the Constitution assigns a decision making to another branch or a decision making on that subject is not apparent to the judiciary thing. It's not good. So political questions are bad. They bad. They real bad. Looking at the powers of Congress. Um, this is going to be in Article 1. Article 1 is Congress. 2 is executive. 3 is judiciary. Article 1, Section 8, Clause 3. This includes all activities involving and affecting 2 or more states. They give Congress power to regulate interstate commerce. They give them that power. Like highways and shit like that, trucks. Any activity that stands to be, that affect interstate commerce. The regulation must not infringe on another constitutional right. The Commerce Clause is a very broad clause. The Congress Clause. It allows Congress to regulate things that may not be economic activity, such as requirement to buy health care, which is ridiculous, but possessing the firearms. Now that's understandable. Power of Congress attacks in Article 1 is it protects and spends Section 8. That's taxing and spending is the exclusive power of Congress. Taxing must have a reasonable relationship to production, or Congress must have the power to regulate the activity being taxed. Congress must spend for the general welfare or public purpose, not to pursue other enumerated powers. Now you're looking at the power of Congress and citizenship or aliens. Aliens have no rights to enter. Entry may be refused, even for political beliefs. That's from Mandela. Aliens already in the United States, this power over aliens is restrained by the Due Process Clause of the Due Process of the Fifth Amendment, and that's from Davis. However, aliens may be removed after notice, and that's 8 USC 1229. Looking at the power of Congress for the improper clause. Congress, they have the power to do things that's necessary and proper. To enact any legislation. They can do that and execute any authority to any branch of the federal government. Actually, that's from McCullough. Now, the necessary proper clause of enact to execute authority by a branch of the federal government was granted by the constitutional to any branch of the federal government. This only allows other powers to be exercised under exam, and the necessary proper clause is never the example if it's by itself. It got to be with a enumerated power, and that completes actually part 1 of criminal law. Uh, criminal law